Most families do not lose control of a house because the house was too small, too old, or too burdened with debt. They lose control because the law does not care what the family meant. It cares who had authority. That is where I want to begin, because the public still tells itself a very comforting lie about homeownership in old age. They say, the house is paid off. The children know what I want. My daughter can step in if something happens. My son knows what to do. Everyone is on the same page. That sounds warm. It also happens to be one of the most dangerous sentences in family finance, because a house is not protected by love. It is protected by documents. A bank does not care who loves you. A county tax office does not care who has good intentions. Social Security does not care who your children are. A hospital does not care who knows what you would have wanted. The legal system is not cruel in some theatrical sense. It is colder than that. It is mechanical. If the authority is not already in place, then the family does not get to improvise when the emergency arrives. The emergency simply exposes what was never built. That is the real story here, not a checklist, not 5 forms every senior should know. The deeper story is this: your home is not just an asset, it is a legal structure. And once incapacity, illness, death, taxes, or probate enter the picture, control over that structure no longer follows affection. It follows paperwork. The file you gave me understands this much better than most consumer content does. On the surface, it presents 5 documents, fine, but the truly valuable insight hidden underneath the list is larger than the list itself. Families do not usually lose the house because they never cared. They lose control because they confused verbal understanding with legal authority, and the law never makes that mistake. That is the sentence I want burned into the reader's mind. The law never makes that mistake. And once you understand that, the whole issue changes shape. It stops being end-of-life paperwork and becomes what it really is, pre-crisis control architecture. That is what these documents are. Not bureaucracy for its own sake. Control architecture. Now let me tell you why this matters so much. A house owned free and clear feels safe in a way very few other assets do. It is visible, it is solid, it is where your children grew up, it is where the years piled up, it is where the mortgage was finally beaten. So people imagine that because the house feels settled, the legal questions around it must also be settled. That is false. In fact, a house without the right surrounding documents is often one of the most fragile major assets a family owns, because so much can go wrong once the owner can no longer act. The file opens with a brutal example. A woman in her 70s suffers a stroke, survives, but can no longer speak or sign. Her daughter tries to step in. The bank says no, the bills keep coming, the property taxes still have deadlines, the home still needs repairs, the account is frozen, not because the daughter is untrustworthy, but because trust is irrelevant where authority was never formally granted. That is how the system works, and if you do not respect that early, the crisis becomes educational in the most expensive possible way. I have always believed that the most expensive word in family finance is not tax. It is assuming. Assuming your spouse can automatically access everything. Assuming your children can sign for you. Assuming the bank will be reasonable. Assuming a verbal plan counts. Assuming the house will just go where you always said it should go. Assumptions are where families light years of work on fire. That is why document number 1 in the source, the durable financial power of attorney, matters so much. I would go further than the source and say it is not merely the first document. It is the bridge between being alive and still being able to govern your own affairs when your body or mind stops cooperating. People misunderstand powers of attorney constantly because they hear the phrase and think it is an old person's extra precaution. It is the legal tool that says, if I become incapacitated, someone I chose in calm times can step into the financial lane before the court does. That difference is enormous. The file is right to stress the word durable. A regular power of attorney can fail at exactly the moment it becomes most necessary. A durable one survives incapacity. That is not a technicality. That is the entire point. A document that disappears when the crisis begins is not protection, it is decoration. And once you see that clearly, another painful truth appears. Family is not authority. That sentence hurts people because it clashes with how love feels. But legally it is true. A spouse is not automatically allowed to act in every financial lane. An adult child is not automatically empowered to sign, transfer, refinance, pay, sell, or manage everything just because everyone knows they are the responsible one. The bank wants authority, the title company wants authority, the county wants authority if you do not pre-build it. Then the family ends up begging a court to create it later. And that later is where disaster begins. The source is right to point at conservatorship and guardianship as the fallback. I want to say the quiet part more plainly. Court involvement is what happens when you fail to build private authority early enough. Sometimes it is necessary, sometimes it protects vulnerable people. But as a default path for a family that could have planned, it is slow, public, expensive, and often socially destructive. Once the court enters, the family is no longer mainly asking, "What did mom want?" It is asking, "Who gets legal control now?" That is a much uglier conversation. The File S. Robert example captures this perfectly. He did what millions of decent people do. He told the kids what he wanted. He thought that was enough. Then incapacity came first, not death. That detail matters immensely because wills speak at death. But incapacity creates a living governance vacuum. That is the vacuum most families are utterly unprepared for. One child tries to help. Another child gets nervous, the court appears, the home sits, bills accumulate, liens appear, repairs are delayed, conflict grows. The house becomes not a shelter but an argument. That is what happens when the family has love but no mechanism. And love without mechanism does not govern property well. Now let us come to the will, because the public almost always understands the will too late and too narrowly. A will is not a magic wand. It is not a family peace treaty. It is not a way of making sure everybody does the right thing. A will is one thing above all else, a set of instructions the legal system can look at after you die when deciding how property in your probate estate should move. That matters. It is important. It is not enough by itself. This is why I think one of the most destructive family myths is the sentence, "Everyone knows what I want." The state does not care what everyone knows. The state cares what exists in legally recognized form. If there is no will, the state uses its own formula. Intestacy law is the government S answer to your silence, and the government S answer may be perfectly clean on paper and completely wrong for your real family. That is why I never treat a will like optional niceness. If you own a home and care where it ends up, you need a will, or you need an even stronger non-probate structure around the home. Otherwise, the state starts dividing according to its own rules, not yours. The file is also right to mention something that sounds dry but can become catastrophic: tangled title. This is one of those phrases people skim past until they discover it can trap a house in a kind of legal fog. The people living there are not clearly the legal owners. The home cannot be sold cleanly. It cannot be refinanced cleanly. Insurance and repairs get harder. Title work becomes painful. A family can believe it inherited the house, while still not having the clean legal architecture needed to actually use or transfer the house well. That is how families stay asset. Rich in cash, poor at the same time. The house exists. Its value exists. Its utility gets strangled by paperwork. That is why I say a will is not merely about death. It is about clarity. And clarity is one of the most underrated forms of wealth. Now let us turn to what I believe is the most practically powerful tool in the whole file for many families: the transfer on death deed or the irrevocable living trust in states where the deed option is unavailable or inadequate. This is where the conversation finally moves from who should get the house to how can the house move without the family getting dragged through probate first? That is the better question. Because the public is far too obsessed with destination and not nearly obsessed enough with pathway. A home passing to the right person 1 year later, after delay, cost, tension, and court friction, is not the same result as a home moving smoothly and privately with minimal interruption. The path matters, the cost matter, the emotional damage matters, the time matters. That is why a transfer on death deed is so important in the states that allow it. The file explains it clearly. You file now, you keep full ownership while alive. You can change it while alive, but once death occurs, the property passes directly to the named beneficiary without being forced through the full probate process. That is a very elegant piece of legal architecture because it preserves control while alive and simplicity after death. That is what good planning does. It reduces friction at exactly the stage where families are least capable of handling more friction. And if your state does not allow that deed structure, then the revocable living trust becomes the next serious tool. I think the source is right to stress that many people get this wrong in a very expensive way. They create the trust and then never fund it. That is one of the oldest mistakes in estate planning. People buy the binder, they feel responsible, they tell themselves they have a trust. But the home was never retitled into it. The trust exists. The house stays outside. probate still waits. That is not planning. That is theater. I say that harshly, because people need to hear it harshly. A trust only governs what actually belongs to it, or what is properly directed into it. If the deed still sits in your personal name and no transfer mechanism is attached, the trust document is just a beautiful story you paid for. The house does not care about the story. The deed decides the path again, not emotion. Mechanism. This is what makes housing and aging such a dangerous combination, when families rely too heavily on verbal understanding. The owner ages, capacity may weaken, the house remains solid, everyone feels basically okay because nothing has happened yet. Then the event arrives. Stroke, fall, brain bleed, dementia, hospitalization, rehabilitation. Suddenly the family discovers that what they had was not a plan but a hope stitched together out of remembered conversations. That is much too thin for a real crisis. Now let us go one layer deeper, because the source wisely begins touching Medicaid and estate recovery. And this is where many well-meaning families accidentally blow up their own future. A home is not just a sentimental asset, it is also a tax asset, a title asset, and a Medicaid asset. That means the decision to transfer it, hold it, gift it, deed it, trust it, or leave it through inheritance cannot be made on emotion alone. Once long-term care, nursing home risk, and post-death recovery rules enter the picture. The home is sitting inside a much more dangerous legal and financial field than ordinary families realize. The file mentions estate recovery and the fact that states must seek recovery for certain Medicaid costs from estates of recipients over 55 in covered categories. Good. That matters, because it destroys another comforting myth. People think the home is always somehow sacred. It is not. It can be exempt for eligibility and still not be protected from recovery later. Those are very different concepts, and families confuse them constantly. This is why I never let people use the phrase, "the house is safe," without forcing them to define what safe means. Safe from immediate liquidation, safe from probate, safe from creditors, safe from Medicaid estate recovery, safe from family conflict, safe from capital gains, safe from incapacity. These are different safeties, different tools solve different threats. That is why the planning must be specific. Now let us come to the healthcare directive, which is where the conversation shifts from property to the body itself. I think one of the most dangerous misconceptions in older households is the belief that one power of attorney covers everything. It does not. The file is exactly right that financial authority and medical authority are separate lanes. A durable financial power of attorney helps govern money. It does not automatically empower someone to make medical decisions, speak to doctors, authorize treatments, refuse interventions, or interpret your values under life-threatening circumstances. That is what the healthcare directive is for. This is not just legal separation, it is moral separation. The person who is good with your taxes may not be the right person to decide about tube feeding. The child who is loving enough to sit at the hospital may not be the right one to manage the property tax accounts. You need to decide these things before crisis turns everyone into improvisers. That is why I respect the healthcare directive so much. Not because it is dramatic, because it spares the family from guessing. Guessing is where guilt grows. Guessing is where siblings fight. Guessing is where a person's final medical chapter gets written by whoever was loudest in the room, rather than by whoever best understood the patient. The file is also correct that a healthcare directive hidden in a drawer is basically a sentimental object, not a working instrument. These things matter only if the right people can produce them at the right time. A directive unknown to the doctor, absent from the hospital, unseen by the named agent, and forgotten by the family does not solve crisis. It becomes a post-crisis regret artifact. That is why distribution matters. Authority must not only exist. It must be findable. That is one of the strongest quiet themes in the whole source. A document not shared is a document only partially completed. Now, let us come to the fifth item, because on the surface the homestead and senior tax exemption application sounds smaller than the others. It is not smaller. It simply operates on a different time scale. The first four documents protect against crisis, incapacity, probate, and control failure. The fifth protects against yearly bleed, and yearly bleed is one of the most underrated enemies in retirement. I have always thought retirees are damaged less often by one sudden giant event than by recurring obligations that remain just a little too high for too many years. Property tax is one of the most dangerous of these because it feels official, non-negotiable, and morally loaded. People assume if relief existed, someone would have told them. That assumption costs a fortune. The file is right to stress that these exemptions and freeze programs are not always automatic. They often require application and sometimes renewal. That is the trap. A person can qualify for real savings and still never receive them, because the system does not chase the homeowner down to say, "You seem eligible, would you like to pay less?" It simply keeps collecting the higher amount until the paperwork says otherwise. That is one of the oldest governmental profits in the world. Silence. A senior homeowner missing a renewal or never filing in the first place is not morally irresponsible. Often they are simply overloaded trusting, or assuming the public system must be more proactive than it really is. That is why I treat the property tax document not as a side note, but as a recurring cash flow defense tool. Lower property taxes do not just save money, they reduce annual strain, they preserve portfolio withdrawals, they widen margin, they make aging in place more financially survivable. That matters more than people think. And then the source introduces the tax trap, which may be the most financially load-bearing detail in the entire video. The house can move in two fundamentally different ways, gift now or inherit later, and the tax consequences are not remotely the same. This is one of those areas where love destroys money when love acts too quickly. Parents think they are simplifying things by deeding the house over to a child while alive. We already know who gets it. Let us make it easy. Fine, emotionally understandable, often financially disastrous, because the child does not receive a stepped-up basis through a lifetime gift. The child often inherits the parent's original basis. That means when the child sells, the capital gain is computed from a much older and much lower number. The tax bill can be enormous. This is the part I want said in the plainest possible English. A badly timed act of simplifying, the transfer of the house can turn family kindness into a six-figure tax problem. That is not a niche issue, that is a life issue. The source's numerical example is excellent because it makes the abstraction hurt properly. A house bought decades ago for a very low amount may now be worth many multiples of that cost. Gift it during life and the old basis carries over. Inherit it after death and under current federal basis rules, the heir often receives a stepped-up basis to fair market value at death. That difference can mean the child sells with little or no capital gain instead of a giant taxable gain. Same house, same family, completely different tax outcome. That is why I say the home is not just where you live. It is a legal and tax engine. Handle it casually. And the engine can punish the family you were trying to help. This is why I dislike broad advice in elder home planning. Put the house in the kids' names. Maybe use a trust. Maybe avoid probate at all costs. Maybe transfer now to protect it. Maybe every one of those sentences can be brilliant in one fact pattern and ruinous in another. That is why the deeper lesson in this file is not the list alone. The deeper lesson is that ownership after 60 must be treated as a system, not a sentiment. Authority, transfer path, medical decisions, tax annuals, tax basis, Medicaid exposure, these all interact. Now let me say something even more important. Most people do not need more information. They need less assumption. That is what I think this file does well when stripped of all promotional wrapping. It breaks the old assumptions one by one. My children can handle it. Not without authority. They know what I want. Not enough. The will handles everything, not during incapacity. A trust solves it. Only if funded, the house is safe. Define safe. If I gift it early, I am helping. Maybe you are triggering taxes instead. Once those assumptions collapse, the family can finally begin real planning. And real planning is not glamorous. It is not something to post about. It is not a Sunday night fantasy conversation at the dinner table. It is a series of boring, adult, legally specific actions that build authority before the body fails, clarity before the court appears, and tax efficiency before the transfer happens. That is what grown-up homeownership after 60 actually is. Not just paying off the mortgage, building the control system around the title. This is why I think the strongest sentence in the whole piece is not file these documents. The stronger sentence is this. If you own your home and you are over 60, the home is no longer just a residence. It is a future legal event that is already approaching, whether you plan for it or not. That is the truth. And once you accept that truth, everything else becomes clearer. The durable financial power of attorney is not just paperwork. It is your living bridge of authority. The will is not for later. It is your voice after death, where state formulas would otherwise speak for you. The Todd deed or trust is not sophistication theater. It is pathway control. The healthcare directive is not about morbidity. It is about preserving your values when you can no longer explain them. The tax exemption filing is not a footnote, it is recurring defense against annual bleed. And the gift versus inheritance decision is not a family shortcut. It is a basis decision that can change the tax future of the next generation dramatically. That is the full system. And it is why the person who waits until the emergency feels real has already waited too long for the easiest options. The file ends by telling the viewer to act this week. Fine, I will say it differently. Do not wait for urgency. Urgency is the penalty phase. The whole purpose of these documents is that they are strongest before anyone emotionally wants to think about them. That is the discipline. A healthy year is exactly when the documents should be strongest. A calm season is exactly when the names should be chosen. The deed recorded, the trust funded, the directive distributed, the exemptions checked, the basis trap understood. That is how peace is built. Not by hoping the crisis will be merciful, by making the crisis less powerful before it arrives. If I had to reduce the whole lesson to one sentence, I would say this. For homeowners over 60, the greatest risk is not that the house loses value, but that incapacity, death taxes, or delay arrive before legal authority and transfer structure have been properly built around the title. That is the real danger. And that is the real opportunity too, because if you understand it in time, so much needless suffering can be prevented. No frozen bank account while bills keep arriving. No sibling war because nobody was empowered clearly. No year-long probate detour just to move one house. No accidental tax disaster because of a gift made in love but structured in ignorance. No annual property tax overpayment because no one filed what should have been filed. That is what good planning buys. Not immortality, not total certainty control. And control is one of the most valuable assets a family can preserve in the final chapters of a life. The house may be made of wood, stone, drywall, copper, and memory. But after 60, the thing that truly protects it is not love alone. It is paperwork strong enough that love does not have to fight the law by itself. That is what these documents are for. That is why they matter. And that is why waiting is so expensive. Because a house can survive storms, decades, taxes, repairs, children, and time. What it often cannot survive cleanly is a family that assumed good intentions would be enough once the owner could no longer speak for it. The law does not hate your family. It simply requires that your family arrive with authority. Build that authority. Now, the home you spent a lifetime protecting has a much better chance of protecting the people you meant it to help after you are gone,